criminal case 2025 CR 0044, State of Ohio versus Carolyn Shireman. This case began, in this court at least, with an indictment from the Crawford County Grand Jury that was returned and filed on February 25th, 2025. This is a, I believe, two-count indictment.
One count.
One count, just one. It says count one. It says count one, I think it's another count. But it's a one-count indictment for theft from a person in a protected class, which is a felony of the second degree under Ohio law 2913.02A1 and B3. The appearances today, we have Matt Crawley, Crawford County prosecutors here on behalf of the state of Ohio, and you are Carolyn Shireman.
Yes, sir.
She is here currently in the custody of Crawford County Sheriff, and John Enterbotter is here.
Yes,
He is representing her. See, your employee counsel is court appointed.
Your Honor, at this point, I've been retained by Ms. Shireman. I already filed a notice of appearance with the court. It should be in the file.
Yeah, I just wanted to make sure, because I saw it. There are some companion cases for CPOs, and I thought.
Yes, sir, there are.
A court appointment in that one, if I'm not mistaken.
Well,
Maybe I'm wrong.
I don't think I've been court appointed on any of those.
Okay, misunderstood it then.
Yes.
I was trying to figure that out. I just want to correct that, make sure I understood.
Yeah.
So you're basically employed counsel in all three of these cases then?
Yes.
Okay. Now, I'm not sure, ma'am, did you receive a copy of this indictment? Did you see this?
Yes, Your Honor, at this point, my client will acknowledge receipt of the indictment, and will acknowledge service of that same for the purposes of the statute, and she'll enter a not guilty plea on behalf of that indictment.
Okay, you're waiving a reading of the indictment? as
Yes,
well?
sir, I'm reading of the indictment and even the penalty sections involved.
Okay, all right. Not guilty, then entered. I guess the question at this point is, and sir, I'm sure you advised her of all of her rights. You wish any further explanation of rights?
Yes, sir, that includes that. I've already gone over those rights with her, and she is aware of those rights as she stands right now.
Mr. Carl, do you have a recommendation at this point as to bond?
Yes, Your Honor. The state would ask that bond be set in the amount of $50,000. The defendant has a previous conviction for telecommunication harassment from 2003 out of Galleon, and also an attempted theft out of Morrow County from 2008. And while those are a little bit older in age for convictions, most importantly, there was a pending intimidation case as a misdemeanor filed in municipal court arising out of the same facts. She allegedly called the victim within minutes of being released from her interview with law enforcement, instructing him that he needed to tell them that this was okay. She also has contacted the Crawford County Board of TD and Bureau of Criminal Investigation, demanding to know if she is being investigated, and then went on social media saying that all of this was made up, potentially poisoning the jury pool. So we obviously would like to see that no longer happen, so we'd ask that she, if she is released, not be able to post on social media and have no contact with the alleged victim. And I can go into the basics of the facts if you wish me to do so, Your Honor.
Let me see.
Sure.
Mr. Meyer, before we go further, I didn't know if you said this, but I tried to find out when she was served, because there's a 24-hour delay waiting that as well.
That's correct, Your Honor. She was, I believe she was served a copy of her indictment on Friday, which would be the 24-hour, I believe that she was served, but if there is a question of when she was actually served, we waive Security as well as her husband's income. She is basically connected to this community, has substantial family ties. So she's not really a flight risk. And the only issue that the state has raised is that she tends to like to open her mouth and talk to people. And if the court is concerned about that, she could be directed to keep her mouth shut as far as talking to the pool horses. On the other hand, I would ask if any type of order to quash or talking would also apply to the state, because we're also concerned the state would also contaminate the jury pool. As to the weight of the evidence involving this case, Your Honor, this is a case involving a gentleman who has been found to be a DD tenancy. However, he's never been found to be disabled under Social Security. He is not, he was in fact been working off and on, and that a lot of the time period that this case is alleging, I believe, is that he was actually out of work, and they were actually supplying him money from their resources rather than him taking his resources. And so it's going to be a factual issue of what was authorized and what was not authorized. So at this point, Your Honor, I believe a personal recognizance is appropriate. We did have a PR bond out of the municipal court, and that court did order her on a GPS unit to ensure that she did not go anywhere near the victim. And in fact, she did not go anywhere near the victim and has cooperated with the state as much as she could based on her orders of her attorney. So that's our position.
Where would she reside if she were released?
She has an apartment that she and her husband are living in. That is not near where
Is her husband James, is that right?
James Shireman, yes.
That's her husband?
Yes, sir.
When I looked at this, it appears as though he was living someplace else.
Your Honor, during the last year and a half, I would say that James was actually residing with, Dougie because they were concerned about Dougie managing based upon injuries he had, as well as some other factors. So James actually resided in Dougie's home, assisting him, but was also providing funds for Dougie's support, since Dougie didn't have a job.
So there's obviously a relationship with
Yes, Your
the
Honor.
alleged victim in this case. Mr. Cole, your response to his request? I mean, you've already indicated what you want, but we'll see if you...
Yes, Your Honor. There were two. It was a life insurance policy cash in and a retirement. The alleged victim had worked for many, many years in the local factory and acquired these funds. And these funds were often used for purchasing women's clothing, regular dog grooming for 5 dogs. The victim only owned 1 dog. Loans for friends and family that they were then told they did not have to repay. Large donations to the defendant's charity. And there's also an allegation involving the will, or the victim's will being changed to make the defendant the beneficiary of receiving the home that's been mentioned. Your Honor, all these things, we have a alleged victim who is one of society, someone who needs protection, and that's what the state's attempting to do here.
And you're prepared to go to trial as soon as...
As soon as the law requires.
Okay, good. Back to you, Mr. Muller. One more follow-up question, excuse me, I'll be back to you.
No problem.
You indicated a record that she has, is that a felony record?
It was a felony reduced to a misdemeanor in Morrow County.
Okay,
Judge Hickson in Framingham.
all right. And that's the only criminal record though?
That's the only felony she had had
She
telecommunication.
did not have, she was not convicted of a felony.
Correct.
So, of course, we do. Ms. Smart, this is a serious offense. It's a felony second degree as charged. She's presumed innocent, I understand all that. It would seem as though it's not an unreasonable request to set a bond such as this. You're asking for an OR bond, and you're saying because she doesn't have the financial capability, is that it?
That, Your Honor, first, there's several reasons the personal recognizance bond is being requested. One is, as a 71-year-old lady, being in a jail would be very extreme difficult because the jail is not geared for a 71-year-old lady to be staying in. Second, Your Honor, this case is revolving around a lot of he said, she said type things. There are a lot of records, a lot of financial records. My office has several records from her. I'm having it started with the state because they have not provided any discovery. But obviously, it's going to be the battle of records about who spent what and whether it was authorized. Because during the time, there's a power of attorney involved, and also there was a fact that there was a lot of stuff that was bought by the alleged victim that he himself bought. And the fact of the matter is, Your Honor, he did, in fact, there is an actual power of attorney involved in here. So, in theory, as long as she didn't use the proceeds for herself, the question is that was the expenses appropriate? Doesn't really fly, except in the question of was it self-serving? And we're arguing that, in fact, it was in fact either requested by the victim or it was in fact done for the benefit of the victim. And with that said, Your Honor, I also keep in mind that I have, in my short time I've been trying to figure this thing out, found over $35,000 that was provided for the benefit of the victim out of resources of the Shireman alone, which means they spent their own money to support him in his house payments and other things. So with that said, I need my client available to go over these records in order for a reasonable attempt to build what is basically her defense. And so a PR bond, I understand the requirement. She's already on and there's already in place a civil protection order. She was been told she should not have any contact with the victim, and she has followed that for over a month while she's been waiting for the grand jury to indict her. So there's not really a question of an escape, of it. She's attempting to hide. She was clearly, everybody knows where she's living. There's clearly not an attempt to, that there's any risk to the community based on this 71-year-old lady. I believe that basically the thing that would be appropriate in this case is a personal recognizance bond. If the court requires to extend a GPS to ensure she doesn't contact the victim, okay, well, we will not disagree with that if that's what the court wants. But we already have a no contact order in place under the civil protection order, and she has not attempted to communicate or been involved with the victim for the last month. So I don't believe anything. I realize this looks like an F2. I personally don't think it's going to boil down to an F2 when we get to actually looking at evidence.
subject to another felony offense coming down the pike for failure to appear on recognizance form. I want you to have enough over your head, man, that you're not going to do anything, because we're going to put some conditions on this that you better make sure you follow. The conditions are, the standard conditions that you all have, you have to pre-trial release if they report.
To our probation department?
Yes.
Yes, it's part of the bond sheet, if you wanted a drug tested or
Yes.
anything like that, yes.
So the standard conditions, do I need to go through them?
It's listed on the bond sheet, it's towards the bottom of the sheet.
Okay. This is what you're talking about, this. Okay. So, basically,
Yeah, and you can write anything you want into there.
Okay.
Or there's also the reporting daily, weekly, monthly. It's up
what do
to
you recommend?
It's our probation staff will do whatever you want, so.
Okay. What do we need, daily, weeklies? Ma'am, you're going to be subject to the standard conditions of the bond, but the special conditions, but basically, the standard conditions of any bond are that you always appear when you're required to appear. And as I said, only bad things happen if you don't appear when you're supposed to be here, especially on the fact that I'm putting a personal appearance bond in place. And that's your promise to be here. And then if you fail to appear, you're looking at another felony of the 4th degree, I believe, for failure to appear on a recognizance bond. Further than the $25,000 bond is subject to 10% rule. As I said, if you put up $2,500, as long as you appear, you'll get 90% of that back. I believe that's still the law. And then you're not to possess or use any alcoholic beverages or drugs of abuse. You're not to possess any drug paraphernalia. You're going to be subject to random drug testing and alcohol tests. You're not to leave the state of Ohio without permission or consent of this court. Obviously, you obey all the laws of the state of Ohio and its subdivisions. You have no contact whatsoever with this alleged victim in this case, Douglas Kotzmeyer. And let me see. That means by any means whatsoever, directly or indirectly. No social media. As a matter of fact, I'd suggest you just have no social media at all from what I've heard here. It's probably to avoid getting yourself sitting back in the county jail if you are released on the $25,000 bond. If you're not, we're going to have to accelerate things and have a quick trial, likely, unless there's a waiver of time. You're to report to the Crawford County Probation Department weekly beginning this coming Monday, March 3rd. I don't know if there's a time that she is to be there, but whatever it is, they'll let you know before you leave here, I'm sure. Or I'm not sure, you'll have to be probably back to the jail to be released if you come up with the bond. Okay. Mr. Kroll, is there any other special condition that you would recommend?
No, Your Honor.
Okay. Do you have any questions, ma'am?
Yes, sir.
Okay. I just want to make sure that you fully understand that a lot of people come back in later on and said, I didn't know that, I didn't understand it. I'm giving you an opportunity right now. If there's anything at all you question about what I just said, please, let's work it out right now. Because I don't want to hear you come back saying, I didn't understand that. Okay, all right. So we need to set a pretrial, and I forgot to bring my calendar, so let me go get that right now. Okay. How far out do you want to set this?
Whenever the court can provide a time that I'm not tied up in court, I'll be happy to. 2 weeks, 3 weeks, would be fine.
Okay,
Typically, case manager sets it within 2 weeks from the date.
Okay.
of arraignment.
well, did you say the case manager sets it?
Yeah, the one that, typically the case manager that does the criminal cases sets them within 2 weeks. And then she'll set another pretrial too.
My calendar is not available to the,
Okay.
so can we set it right now?
Yeah.
Okay, all right. That would take us to the week of the 10th, I believe.
Yes, Your Honor.
I am available the morning of the 12th. Other than, I'd have to go to the 19th the next week if we can't do it on the 12th.
Your Honor, I'm available probably after 10:30. I have a juvenile court matter at 9:30 in juvenile court downstairs. After that, I'm available whenever the court's on the 12th. The 19th, I would be, I've got pretty much most of the day at Upper Sandusky.
Okay. Mr. Carlos, does the 12th work for you?
The 12th would be fine. The court does have a jury trial that may be going,
Oh,
likely going to be, but we could use one of the other courtrooms.
okay. Would that,
Fine with the court.
would we be able to do that?
Yeah.
What time, Mr., you said 10:30, you say? Mr. Motter?
10 after 10:30, Your Honor, yes.
Are you saying maybe 11 then?
Your Honor, I have my calendar shows about me tied up approximately an hour, and that's normal about for juvenile court, GAL stuff. And then so 10:30 to 11, either, if you would like 11, I have no
Well,
problem.
10:30 is fine. I thought that you said after 10:30.
Well, I'm just saying, not
Okay.
before 10:30, so yeah.
Okay, 10:30, okay.
10:30 it is.
So I'm also thinking about these CPO matters, because I'm not going to be available for the hearing that's scheduled for next week.
Yeah, Your Honor, basically, my position, I've had a talk with my clients concerning it. We have no objection to extending it out beyond next week. To me, it's, the issue of the CPO really only becomes important once we resolve the felony case. So, if
Okay.
the court wants to make an order that it extends it out for basically the initial protection order out for another 3 months, 4 months, to give us all a chance to get caught up to where we are, we have no objection.
Mr. Crowe?
I did just notice on the court schedule, I thought that trial started earlier in the week, but that day, the 12th is jury selection, which maybe, I guess
You'd have a prosecutor available?
Yes, we do.
Okay.
We have one of us is available.
Okay. Annette, you see any problem with that?
No.
Okay.
I will be available too, so we're looking at 10:30 on the 12th.
Right.
And it looks like either courtroom, magistrate's courtrooms would be available. Probably Tim's, since we have a jury trial going on this side of it.
So, I know this doesn't apply directly to this case we're here on, but the other case was a CPO for,
Yes, sir.
and you represent both her and her husband. So
Yes, sir.
what I think I'm going to do is put an order on that's going to be continued indefinitely, but the CPOs will temporarily remain in place
Yes, sir.
pending a hearing, and we'll get the other attorney as well, because he represents, I guess,
Mr. Gentleman represents,
yeah, right. Because we're not sure of his ability, so it might go out several months, but we'll come up with some date that clears.
yes, sir. The next thing I would expect the court to be involved in is we're attempting to get Mr. Shireman's property that they've actually walked through the property with Mr. Kotzmeyer and friends. And I would anticipate that we will be filing a motion to get a court to order the release of the property you asked for in a letter or in
Yeah.
a list to the court. We would be asking the court to allow us to go in and get those property out. But that, again, has to be dealt with. The state here can't deal with that, and, but as far as leaving it alone for 3 months to get to that, I have no problem with that.
Okay. So basically, the temporary orders, which are due to expire, I think, on the 9th of March, will
Yeah.
continue on until further order of the court.
Yes, sir.
Okay. That's okay with the state, I'm sure.
Yes, Your Honor.
Okay. So we'll schedule this pretrial then for the 12th at 10:30, unless she's still incarcerated at that time. We'll probably get a trial schedule
Yes, sir.
that will be more, I guess, conducive to the things that you all want to do, and that is to make sure you get full discovery and you're not pressed for time, but otherwise, we might have to accelerate if she's still incarcerated. I presume she won't be, but I don't know for sure.
Yes, sir. I appreciate it.
Okay. Is there anything further for the record then?
No, Your Honor.
No, sir.
All right. Then we'll terminate the record. Thank you.
Thank you, Your Honor.